Imagine you are standing on the wind-swept shore, watching a ship carrying your loved ones approach the harbor. You have been waiting for years, enduring the profound pain of separation, the missed birthdays, the lonely holidays, holding on to the promise that if you just followed the rules and waited your turn, they would eventually arrive. But suddenly, just as the ship is within sight, the harbor master changes the rules. The ship is turned away, sent back out to sea to circle aimlessly for more years, while other ships are allowed to dock. This is the precise, heartbreaking reality facing thousands of families right now as the Department of Homeland Security and USCIS quietly roll out a massive structural overhaul of the I-130 petition processing system. Starting in February 2026, the first-in, first-out logic that has governed family immigration for decades, the idea that fairness means waiting your turn, is being dismantled and replaced with a complex, tiered priority structure that will pick winners and losers based on new, often opaque criteria. If you have a petition pending, or if you are about to file for a spouse, a parent, or a sibling, your timeline may have just exploded from months to years without you even knowing it. This isn't just a delay. For many, it is a denial by attrition. Welcome back to U.S. Immigration Insight, the channel that refuses to let you navigate this storm blind. Today, we are dissecting the new I-130 priority rules with forensic precision, exposing the hidden delays that are about to crush siblings and adult children, and giving you the strategic playbook you need to protect your family's place in line. This is not just news. This is a survival guide for your immigration journey in a system that is actively changing the map. To truly understand the magnitude of this shift, we must first look at the broken machinery of the current system and why this change is happening now. The I-130 petition for alien relative is the bedrock of legal immigration. It is the first step in bringing any family member to the United States. Historically, these petitions were processed roughly in the order they were received, subject to the workload of specific service centers like California, Texas, or Nebraska. It was an imperfect system, plagued by backlogs, but it was ostensibly fair in its chronology. However, under the crushing weight of a historic backlog, millions of pending cases that have piled up since the pandemic, USCIS is pivoting to a triage model. They are moving from a processing model to a prioritization model. The new February 2026 guidelines effectively split families into three distinct classes of priority, creating a caste system of family reunification. Tier 1, the fast track, is reserved for the spouses and parents of U.S. citizens. The target processing time for this tier is aggressive, 6 to 9 months. This is fantastic news for anyone in this category, potentially cutting current wait times in half. It reflects a policy decision to prioritize the nuclear family unit of citizens above all else. But resources in a bureaucracy are finite. If you move officers to speed up Tier 1, they must be taken away from somewhere else. That somewhere else is everyone else. Tier 2, the moderate track, covers minor children of U.S. citizens and the spouses and children of green card holders, the F2A category. These groups are seeing their target processing times slip to 12 to 18 months or longer. But the real crisis, the silent catastrophe, lies in Tier 3, the standard track. This tier becomes a parking lot for everyone the system deems lower priority. Unmarried adult sons and daughters, F1 and F2B, married children of citizens, F3, and the brothers and sisters of citizens, F4. For these groups, processing times for the I-130 petition alone, not the visa, just the initial form, are projected to balloon to 36 months, 48 months, or even longer. This policy change creates a dangerous double backlog. In the past, even if a visa number wasn't available for a sibling, F4 category, for 15 years, USCIS would often approve the underlying I-130 petition within a year or two. This approval was crucial. It meant the family had a locked-in priority date. It meant the government had formally recognized the relationship. It gave the family peace of mind that their eligibility was secure, even if the wait was long. Now, By deprioritizing these low-value petitions to the bottom of the pile, USCIS is leaving them in limbo for years without adjudication. This is catastrophic for several reasons. First, evidence gets lost or becomes harder to obtain as years pass. Second, policies change. A future administration could eliminate the sibling category entirely. And if your I-130 hasn't been approved yet, you could lose your grandfathered status. Third, and most tragically, if the petitioner, the U.S. citizen sponsor, dies before the I-130 is approved, the petition dies with them. Under the old system, humanitarian reinstatement was easier to argue if the I-130 was already approved. Under this new system, thousands of families may see their hope of immigration extinguished forever by the death of a sponsor during the prolonged processing delay. Furthermore, the new administrative prioritization factors introduce a layer of opacity that is terrifying for applicants trying to plan their lives. USCIS has indicated that cases where the beneficiary is already physically present inside the U.S. and thus eligible for concurrent filing of adjustment of status may move faster than those where the beneficiary is outside the country waiting for consular processing. This creates a perverse incentive and potentially punishes those who waited abroad as the law requires. Additionally, clean cases with perfect initial evidence will jump the queue over those that receive a request for evidence, RFE. In the past, an RFE meant a delay of a few months. Under this tiered system, if your file is pulled for an RFE, it might be thrown back to the bottom of the pile, costing you years. This means a single missing birth certificate translation, a blurry passport scan, or a forgotten signature could be the difference between seeing your family in 2027 or 2030. The margin for error has vanished. The impact on aging out children cannot be overstated, and this is where the technical details become heartbreaking. The Child Status Protection Act, CSPA, is a complex formula designed to help keep children classified as minors, under 21, for immigration purposes, even if they chronologically turn 21 while waiting. The formula allows you to subtract the time the I-130 was pending from the child's biological age at the time a visa becomes available. Ironically, a longer I-130 processing time can actually help some children by freezing their age for longer. However, the interplay between these new processing delays and the Visa Bulletin movement is unpredictable. By artificially manipulating processing times, USCIS is throwing a wrench into CSPA calculations. For some categories, a faster approval might actually hurt the child by stopping the age freeze clock too early, while for others, the extended delay might push them past other deadlines. It turns the protection of children into a game of bureaucratic roulette. So, what is your battle plan? How do you fight a system that is rigged against you? Action is your only recourse. Passive waiting is no longer a strategy. It is a risk. First, if you are eligible to file an I-130 for a family member, do not wait. Do not wait for a birthday, a bonus, the right time, or next year. File now. Petitions submitted before the February 2026 cutoff date will likely be grandfathered into the current processing queues, potentially saving you years of waiting. If you file today, you are in the old system. If you file in March, you are in the new tiered system. That difference is worth gold. Second, if you have already filed, you must audit your own case. Ensure your address is updated with USCIS. Missing a notice in the mail is fatal. Ensure your evidence is bulletproof. If you suspect your initial filing was weak, consider uploading unsolicited evidence to your online account to strengthen the file before an officer reviews it. Ensure your online account is active and you are checking it weekly. Third, if your case is languishing beyond the posted processing times, do not suffer in silence. The squeaky wheel gets the grease. Utilize congressional inquiries. Contact your local congressperson or senator's office and ask them to inquire about your case. Utilize the USCIS Ombudsman for cases with clear errors. And if necessary, and if you have the resources, consider federal mandamus litigation. A writ of mandamus is a lawsuit filed in federal court asking a judge to force USCIS to make a decision on your case. It doesn't guarantee an approval, but it forces a decision. In an era of indefinite delays, a lawsuit is often the only way to break your file out of the Tier 3 parking lot. Fourth, for green card holders who are sponsoring spouses or children, naturalization has never been more urgent. Becoming a U.S. citizen is the ultimate cheat code in this system. It instantly upgrades your family members from the slow, capped preference categories, F2A, F2B, to the immediate relative category, Tier 1, bypassing the wait times entirely. If you are eligible for citizenship, apply today. It is the single most effective thing you can do to speed up your family's arrival. We are entering a new era of tiered justice in immigration, where the definition of family is being narrowed by administrative fiat. The government is signaling that some relationships, spouses, parents, are essential, while others, siblings, adult children, are optional and can be made to wait indefinitely. This is a profound shift in American immigration values. At U.S. Immigration Insight, we refuse to accept this quietly. We will continue to monitor every memo, every data release, and every policy shift. We will analyze the fine print that the government hopes you won't read. We will keep you ahead of the curve so that you can make informed, strategic decisions for your loved ones. Your family is not a statistic, not a file number, and not a Tier 3 priority. They are people, and we will help you fight for their future. Let's delve deeper into the mechanics of this tiered system and why it is happening. The sheer volume of applications has overwhelmed USCIS. They are understaffed and underfunded, despite fee increases. The decision to prioritize Tier 1 applicants is a political and practical one. Spouses and parents of citizens are the core of family unification policy. However, this creates a zero-sum game. Every officer assigned to adjudicate a marriage case is one fewer officer adjudicating a sibling case. For Tier 3 applicants, this means your file is gathering dust. The active review status on your online portal becomes a lie. Your case is likely in a storage facility, untouched for years. This indefinite delay has secondary consequences. Medical exams expire and must be redone, costing hundreds of dollars. Police certificates expire, passports expire. The administrative burden of maintaining a pending case for 5 years is immense. Families must be vigilant about keeping every document up to date, ready to spring into action the moment, if ever, their number is called. The administrative prioritization factors also deserve closer scrutiny. The preference for beneficiaries already in the U.S. suggests a policy tilt towards those who have already established a foothold, perhaps via student or work visas. This leaves those who followed the rules and waited abroad at a disadvantage. It risks encouraging visa overstays or creative interpretations of visa intent, as families realize that being on U.S. soil is the only way to get priority. Furthermore, the penalty for RFEs is draconian. In a high-volume, low-touch processing environment, officers are incentivized to move cases off their desk. Issuing an RFE is faster than a denial, but slower than an approval. If your case is messy, it gets sidelined. This underscores the absolute necessity of a perfect initial filing. No missing pages, no blurry photos, no mistranslated documents. If you are doing this yourself, triple-check everything. If you can afford a lawyer, get one to review the packet. The cost of an error is no longer just a delay. It is a relegation to the back of the line. Let's talk about the F4 category for siblings again, because it is the most impacted. Critics of chain migration have long targeted this category. While legislative attempts to eliminate it have failed, this administrative change achieves the same goal through bureaucracy. By making the wait times practically infinite, the government discourages new filings. Who will file a petition today knowing their sibling might not arrive for 25 years? It effectively kills the category without changing the law. For families already in line, it is a betrayal of the promise made when they paid their fees and filed their forms. They played by the rules of 2015 or 2020, only to have the rules of 2026 applied retroactively to their processing times. This raises serious questions about fairness and reliance interests that may eventually be litigated in court. For those in Tier 2, the F2A category, spouses and minor children of green card holders, the slip in processing times is alarming. This category was current for a long time, meaning no wait for a visa number. Now, a backlog has developed in the Visa Bulletin, and the new I-130 processing delays will exacerbate it. A green card holder might file for their spouse, expecting a 1-year wait, only to find themselves separated for 3 or 4 years. This strain on marriages is immense. It forces families to maintain 2 households, often on a single income, creating financial hardship. It delays the integration of the immigrant spouse, who loses years of potential U.S. work experience and credit history. What about the Child Status Protection Act, CSPA, nuance? This is complex. CSPA allows you to subtract the time the I-130 was pending from the child's age when the priority date becomes current. If an I-130 takes 5 years to approve, you get to subtract 5 years from the child's age. If it is approved in 6 months, you only subtract 6 months. For families in backlogged categories like F3 or F4, a slow I-130 approval is actually better for CSPA purposes because it buys more frozen time. However, this is a dangerous gamble. You are betting that the Visa Bulletin will move fast enough to capture that frozen age. With the new Tier 3 delays, you might get a lot of frozen time, but if the Visa Bulletin itself stops moving, as we are seeing, it might not matter. The child might still age out. This requires a sophisticated mathematical analysis of your specific priority date and the Visa Bulletin trends. Do not assume your child is safe. Consult a lawyer to run the CSPA calculation. Finally, we must address the emotional toll. Immigration is not just paperwork, it is people. It is the anxiety of checking the mail every day. It is the fear that a parent will pass away before the approval comes. It is the stress of missed milestones. This new tiered system adds a layer of psychological burden. It tells some families, you matter, and others, you can wait. It is a cold, administrative judgment on the value of relationships. At U.S. Immigration Insight, we see you. We know that a brother is as important as a spouse, that an adult daughter is still a child to her mother. We validate your frustration and your anger, but we also urge you to channel that energy into action. If this deep dive analysis empowered you, if it gave you clarity in a time of confusion, please like this video, share it with your community groups, and subscribe. The more we grow, the louder our voice becomes, and the more we can hold the system accountable. We need to build a community of informed applicants who can advocate for themselves. Share your stories in the comments. Let us know how these delays are affecting you. Your testimony is powerful. Stay strong, stay informed, keep your documents ready, and never, ever give up on bringing your family home. The road is getting harder, but the destination is still worth the journey. Thank you for watching U.S. Immigration Insight. We will be here with you every step of the way.